Okay. Thank you, Professor Bing Guanzon, who is from Harvard and not from Yale. Well, actually, I originally thought that my job was to provide some useful comments to the lectures of our honorable members of Congress and the President of the IBP until after I saw the invitation, which referred to me as a lecturer and referred to our speakers as people will simply provide messages. I think that was meant to route around the gag order of the Senate more than anything else. In any case, Congressman Sani Angara, future Senator of the Republic, and my classmate, Congressman Miro Kimbo, who is not my classmate, but is also a future Senator of the Republic. My boss at the IBP editorial board of the IBP Journal, President Ron De Barrios, Dean Danilo Concepcion, who's still choosing between becoming a Senator of the Republic and the next Chief Justice of the Republic. Colleagues in the faculty here in law school and in the university, guests and fellow students of law, good afternoon. Right. Okay, impeachment. Okay. When it comes to debates about impeachment, it's very difficult. In fact, it's very easy to end up into dichotomizing the debates. And given that our speakers this afternoon come from different sides, in fact, it's very inviting to see the entire process as coming from the polar opposites. And so what I'd like to do this afternoon is to provide you with some tools of analysis from the perspective of an academic, from the perspective of a constitutionalist. My job is not to adjudicate whether or not the pro-impeachment side is correct or the anti-impeachment side is correct, but to perform my role as an academic, which is to use the tools of constitutional law to determine whether or not the arguments that have been presented are weightier than the others, especially given the fact that the arguments have been very well presented, which is what you can expect from graduates of this institution, regardless of where they stand. Right? And so I'll give you what I consider to be at the core of the debate, which is a conversation about the nature of impeachment. Right? And the answer to this is usually seen in terms of, well, impeachment is a political process, and impeachment is a legal process. Well, the honest answer to that particular question is that, well, there's an element of the political in the legal, and there's an element of the legal in the political. And so the best way to approach the issue, I think, is to ask the question, political in terms of what? Legal as compared to what? Right? Because if you listen to our speakers, it's very easy to see them as providing you with some operative assumptions as to what they're saying, meaning that if you couch the impeachment process in terms of the political, then the necessary consequences are as follows. There's an immunity from the legal process, especially the certiorari powers of the Supreme Court. There's a very large leeway on the part of the members of the House and of the Senate in terms of determining the propriety of their actions. And finally, there's a opening for greater participation by the public. On the other hand, if you look at it in terms of a legal process, it should remind you of what Counsel Estrito Mendoza kept on repeating over and over again during the impeachment trial, which is a reference to the word guilty. And because the Constitution uses the word guilty, then this is nothing less than a criminal proceeding, and the consequences are the rights of the accused should be followed. You have a very high standard of evidence required, and in case of violation of the rules, then there's a possibility of resort to the Supreme Court. Right? Like I said, there are very good arguments for and against, and my job is to provide you with those tools of analysis. And the way to analyze all these things is by looking at what always referred to as the 3 pillars of constitutional analysis, which is what? An analysis of the text, an analysis of the history, and an analysis of constitutional structure. By analyzing text, history, and structure of the impeachment clauses, then we can have a well-grounded understanding of what an academic can say about the nature of the impeachment process. Let's start with, I'll try to keep this lecture as being refers to as short as possible, but give you enough items to talk about for the Q&A. Let's start with the text of the Constitution. The Constitution says in Article 11, Section 2, the President, Vice President, the members of the Supreme Court, the members of the Constitutional Commissions, and the Ombudsman may be removed from office on impeachment for and conviction of culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, or betrayal of public trust. I mean, if you belong to the category of those who believe that this is a legal process, then you might want to latch on to the terms treason, bribery, graft and corruption, other high crimes. Why? Because these are reference to well-defined terms in the revised penal code, right? And so if you follow the line of Estelito Mendoza, you will say, well, this is nothing less than a legal process precisely because the impeachable offenses are couched in terms that are understandable from a criminal law perspective. On the other hand, there is this interesting phrase, right? Betrayal of public trust. And so I've been asked often, what do you mean by betrayal of public trust? And my answer has always been, well, you can analogize it with another procedure that is famous in parliamentary governments, which is what? The vote of no confidence, right? And so the vote of no confidence, right, is akin to betrayal of public trust in the sense that this is some sort of a confidence check. Nothing to do with facts as provided in as may be established in a criminal litigation, but a pure confidence check, right? We have lost confidence in you, and therefore you're out, right? And so they should remind you of the famous line from Oliver Wendell Holmes about the problem of, entrusting our fate in the people. And his answer was, if the people want to go to hell, I will help them. That is my job, right? And so if the people are no longer confident in their impeachable public officers, you might want to say, well, this is the resort whenever we lose confidence. Why? Because even if we replace the Chief Justice with someone who is incompetent, right, then it is our fate that we have decided, we internalize the cause of our decision. So that's on the side of those who claim that this is a political as opposed to a legal process. I'll refer you to another provision of the Constitution, subparagraph 4 of the same article. In case the verified complaint or resolution of impeachment is filed by at least 1/3 of all the members of the House, the same shall constitute the articles of impeachment, and trial by the Senate shall forthwith proceed, right? Is there anything in this text that can, indicate to us the nature of an impeachment proceeding? Well, yes, and it has everything to do with a distinction between the proceedings in legislature and the proceedings before the court, specifically the Supreme Court. See, the Congress is not necessarily a deliberative body. They deliberate on second reading, but that's not what makes a bill a law, right? It's actually the vote, right? Compare this to, for example, the proceedings in the Supreme Court, where our magistrates are actually required by the Constitution to explain their decisions. There's no requirement under the Constitution that members of the House or even members of the Senate particularly explain their decision. The only requirement is for them to actually vote, right? And it's the vote that makes them accountable to the people. So whenever people ask me, what about this argument that the impeachment complaint apparently wasn't even read by the members of the House who signed on to the impeachment? I have two questions in reply to that question. Number one is, well, do we actually require of the members of the House that they actually read the bills that they sign on to? I mean, you're laughing, but it provides you with a very important insight into the legislative process, which is, again, not that they are required to deliberate, but that they are required to vote. And so only if you are willing to question the validity of laws that are passed by Congress, whose members may not have read, right, the bills that they pass, right, can you make a strong argument that just because the articles of impeachment are not read by the members of the House, then you can question the constitutionality of that particular proceeding. And again, so far as I know, no one among the members of Congress who signed on to the impeachment complaint have said they have been defrauded into signing on to the impeachment. And I think the most important question is, so long as they knew what they were signing on to, which is that this was an impeachment complaint, then you can make the argument that, yes, they have complied with the constitutional requirement. The question of verification is a question of fact, and so I won't go into that. Let's now go to another provision of the Constitution, another text. Subsection 6 of the same article. The Senate shall have the sole power to try and decide all cases of impeachment. You see, constitutionalists, whenever they hear the word, whenever they read the word sole, right, it's an immediate reference to a doctrine, right? A famous line in American Decision, which has been famously quoted over and over again in the Philippines. It is this doctrine that whenever the Constitution uses the word sole, right, in one particular provision, it is a textual commitment, right, of a particular power to that branch of government. And whenever you refer to a textually demonstrable constitutionally committed power to a branch of government, right, your next step would be to speak about political questions, right? In the United States, right, they've been very stringent when it comes to applying this particular provision of the Constitution. The reference to the sole, there's one famous case where the Senate even decided to delegate the power to try to a subcommittee of the Senate, and there's a question as to whether or not this violated the Constitution. The U.S. Supreme Court said, the Constitution uses the word sole, and therefore let the Senate decide whether or not, what type of trial they want. Let me now go to history, which provides you an even more complicated, right, set of artifacts for analysis. You see, it's very easy for lawyers to resort to colonial mentality and start citing decisions of the United States Supreme Court. But I would always say it's not really the citation, right? It's the value of that citation that should matter, right? Whether or not, you know, the history of the United States jurisprudence on impeachment, right, will have some application to the way we see our impeachment process here, right? And so for me, I would actually localize resort to impeachment to what? The history of the impeachment process here in the Philippines. And foremost in my mind would be the impeachment process of Chief Justice Davide, right? Anyone who claims that the impeachment process is a purely political process, right, should take pause and read Francisco versus House of Representatives, where the Supreme Court actually intervened in that process, right, to stop the impeachment trial of Chief Justice Davide. Yes, it smacks of conflict of interest, but it's there in the SCRA, and therefore you might as well read it. The other perspective is to ask this question: whether or not it's really the action of the Philippine Supreme Court in Francisco versus House of Representatives which stopped the impeachment, or the fact that the House and the Senate really did comply with that decision. Imagine if the House of Representatives under Jose de Venecia decided to say, oh no, we are not going to follow the decision of the Supreme Court. Why? Because they suffer from conflict of interest. And the Senate says, yes, we believe the House of Representatives are going to proceed with the impeachment of Chief Justice Davide anyway. That would have been a real constitutional crisis. And so those who say, well, grave abuse of discretion clause can be dangled as a check on the power of the House and the Senate to impeach public officers, might as well, you know, look more deeply into what actually happened in Francisco versus House of Representatives. The final tool of constitutional analysis is the analysis of the constitutional structure, right? So here the question is, if you're saying that the impeachment process is a political process. Again, the relevant question is compared to what, right? And the structure of the Constitution gives you some powerful ideas as to why the impeachment process is a political process in the sense that I referred to, right? Look, the impeachment process is not a power given to the ombudsman. The impeachment power is not a power given to the Sandigan Bayan. The impeachment power is not a power given to the Secretary of the Department of Justice or to the Court of Appeals, all of which are legal institutions in the traditional sense. The impeachment power was granted to a purely political organ of the government, right? The House of Representatives and the Senate, right? And so if you look at the text, history, and structure of the Constitution, right, you can, well, make the reasonable argument that, well, as to the question of whether or not this is a political or legal process, a good answer would be this is really more of a political rather than a legal process. It might make you think that I am for the impeachment of Chief Justice Davide, but that's only because I'm only done with the first part of my presentation. The second part of my presentation is the part where I get out of my comfort zone and start speculating. Right? Again, underlying this debate about the nature of the impeachment is the nature of the entire process which we are undergoing right now. And so the question is, how do you define what is political in the first place, right? And I refer you to the metaphors of photography, my other current fixation, right? You see, you can use a telephoto, right, and use a very narrow lens to define the word political. Political in the constitutional law sense, political in the doctrinal sense, political meaning that the Supreme Court should not touch these proceedings, that the Senate should be allowed greater leeway in trying the Chief Justice, right? Or that the people should participate, right? But you can adopt a wide-angle lens, right? And define political in terms of, well, Dina Gabin is not here, in terms of purely a contest for power among the elites, right? It's a very relevant, and I would say, in fact, the kind of lens that non-lawyers should adopt. You see, this debate among lawyers, right, and all of us here are lawyers, right, really excites us because this is the stuff, right, for which 4 years of education pays, right. We have mastered the jargon, and therefore we can unleash ourselves upon the innocent public and tell them we're so good, we're from UP College of Law, right, because we control the jargon. But if you adopt a wider lens, right, and ask, what do you mean by political? You're down to a contest between the metaphors, right, of the President and of Chief Justice Renato Corona. The metaphor of the President is that this is a battle for public accountability. Yeah, well and good. The metaphor of Chief Justice Corona, which is in the headlines today, is this is a fight for democracy. Yeah, well and good. But the thing is, we weren't born yesterday, right? And we have been blindsided often enough, right, to say that we can pierce the veil of metaphor and ask more relevant questions. And these questions that I will ask later, which I will use to conclude my short presentation, are questions that I did not ask because I don't want to get into trouble, right? Which is very good, right? This question was asked by Bobby Tiglao, right? Forget about his bias, but try to assess the merit of what he said. This is not really about public accountability. This is about a president who's trying to protect his clan because of the Hacienda Locosita decision, right? And again, this is outside my comfort zone, but because I am also a citizen, because you're citizens, it does pay to ask whether or not there's some legitimacy to this particular claim, right? The other is this. I'm referring to a hashtag by one of my colleagues who, I'm not going to refer to him, of course, one of my colleagues who's doing his master's in the United States. The hashtag says, someone wants to be CJ. Is this entire proceeding simply about the ambition of one man to become a Chief Justice, right? I mean, this is the job for the investigative journalists and the historians of the future, right? Someone in the dining hall of the UP College of Law would say, this is all the makings of a frat war, right? Both in Ateneo and here in UP, right? Right. I can hear Professor Labitag smiling and laughing right now. Right. Someone also told me this is not really about accountability. This is about 2016. All you have to look for is the votes in the House and the way the important players here are playing to know that this is about 2016. Long term, medium term, this is about 2013. I don't know. These are questions that are being asked. And these are relevant questions, highly speculative questions, but impact on the credibility of the metaphors that are used, right? And for me, the most important question is, if this is simply a Game of Thrones, who are the houses and what are their interests, right? And then ultimately, right, to borrow from one of my colleagues in the Institute of Government and Law Reform, because we are the people, maybe we should ask, baka naman this is just aliens versus zombies. Kahit sino manalo, talo ang taong bayan. Thank you and good afternoon.